Hello, my name is Van Smith, managing partner here at Smith Strong, and I'd like to go over the most common question our intake folks are asked from clients calling in before they schedule their estate planning, will or trust consultation with us. And that is, hey guys, should I get a will or a trust? How do I know which one to get? How do I know what's right, what I need for my situation? Well, we've got an answer for you. Every single week, by Zoom, online, or in person, we have a quick 1 hour and 5 or 1 hour and 10 minute, depending on questions, workshop. Online, you can watch it on your smartphone or laptop or computer, or come in person to this table. And we do it live for free as a community service every week in this office, sometimes multiple times a week. And it answers that very question. But let me give you a little guidance here and a little appetizer here for the workshop, okay? Wills are appropriate when there are low asset, meaning if you're a family and your household has less than 200,000 in assets, if you are a renter and you are living Social Security check to Social Security check and you have a bank account or a retirement account of say 150,000 or less, and that is all you own, except for maybe a car and a bank account, and you do not own a home, you do not have life insurance, and you're living essentially paycheck to paycheck on Social Security, well, then we're in preservation mode. And we just want to make sure whatever is left it is distributed to the heirs and beneficiaries you care about. And so we will very diligently make sure you have the appropriate will and the documents to see you through your elder years. Like what? So in addition to a will, we want to make sure you have a power of attorney, advanced medical directive. Power of attorney is financial. Advanced medical directive is medical. And then living will. What's the difference between a will and a living will? Well, the living will is pulling plug if in a permanent vegetative state with no hope of resuscitation. And then, of course, HIPAA. Since 1996, the federal government has said, look, your advanced medical directive must also have a HIPAA. Then we have a personal effects section. So all of your sentimental items go to the right child or heir. And then finally, memorial instructions. We want to know if you wish to donate organs or not, if you wish to be buried or cremated or some alternative method. And so this is a will-based plan. We add a trust when there are higher assets. But that's not all. It's not just an asset test. It's a value test. So watch this. When we add a trust, we're adding a trust to gain more protection for you and your finances when you're no longer able to speak for yourself. Imagine if you're have a dementia or Alzheimer's diagnosis, or you're in a coma, or you're in and out of consciousness because of a medical issue, and now someone else is managing your finances. Well, there's much more fiduciary control and accountability through a trust. Also, by adding a trust to your estate plan, you avoid probate, meaning instead of 2 to 3 years and 3 to 5% in cost, which happen with a will, you avoid that, and it's 2 to 3 meetings with our firm or the attorney of your heir's choice. So the first big value add by adding a trust is protection of your finances, then avoiding probate. Then you're good in all 50 states. Why? Unlike a will that is a state law-based document, if you plan to move in your retirement years or have properties in multiple states or jurisdictions or territories, it would behoove you to consider a trust, because a trust is a federal law-based document. You avoid probate in no matter where you move or have property when you die. And then finally, if you have children or heirs that you're particularly close with, I find those people then want, if they have children or heirs that they're very fond of and wish to make sure that they're well cared for, adding a trust allows us to then give them their share via trust. So thank you, mom, dad, grandma, grandfather, or uncle or aunt. They get their inheritance from you, and it's protected. So they can have access to it, but no one can take it from them in a divorce or a divorce or a divorcing context or bankruptcy or litigation. The biggest predator to your child or heir's Inheritance is their divorcing spouse or their creditors or bankruptcy litigation or business failure or their own disability event. And so we still want them to get it, but get it protected. And so we talk about this in our free workshop. If you're totally against the workshop and don't want to attend, even though it's free and online or in person, that's okay. We don't force it. You can still meet with us if you want to avoid that. But here's the benefit to the workshop. You get effectively 3 hours with us, kneecap to kneecap, learning and drinking from the fountains of the wisdom of our years of experience before you have to make any decisions, instead of skipping the workshop and only having an hour, hour and a half with us before decisions then must be made. And so we find that the client satisfaction ratings are way higher for those that trust us, attend the workshop for free, and then entitled to the free consultation as well. We look forward to helping you wherever you are in that process, and I hope this was helpful. We look forward to serving here at Smith Strong as your long-term legal advisor. We take that very seriously because we know the stakes are high. We want to be there to support your family upon incapacity or death of each of our clients. And so that's why our firm of now over 30 people, we have teams to support you and your family no matter what comes next. Thank you.